Good day, everyone, and welcome to today's Phoenix Center Teleforum USTelecom v. FCC, a legal and economic post-mortem. At this time, all participants are in a listen-only mode. Please note this call may be recorded. I will be standing by if you should need any assistance. It is now my pleasure to turn the conference over to Mr. Larry Spiwak. Please go ahead.
Well, good morning, everybody. Thank you so much for joining us. My name is Larry Spiwak. I'm the president of the Phoenix Center, and I'm sure as everybody knows by now, the D.C. Circuit this week has come out with its landmark case in USTelecom v. FCC, upholding the FCC's open internet order. And so what we'd like to do today is, I realize it's been a very short time, and even with the most talented of folks, reading 180 pages and digesting it thoroughly is very difficult in less than 48 hours. But we're going to try to provide some insight to the case and its implications today. So I'd like to thank everybody for joining us, and I'd like to introduce our panelists. I'm very delighted they can all join us. We have, in no particular order, Jeff Lanning from CenturyLink, Hank Hultquist from AT&T, Russ, Hanser, who's a partner over at Wilkinson Barker, and my partner, Dr. George Ford, who's the chief economist of the Phoenix Center. Everybody on this call has a tremendous amount of telecom experience, and we're very, very lucky, and we look forward to their insights. So the case is what the case is, and I think anybody can read the case and decide what they want to take away. What we would like to do today is sort of skin the cat slightly differently and focus on two sort of interrelated topics. The first being, what exactly did the court say here? Actually, three things. Is there some sort of vulnerability in terms of an appeal? And I want to be upfront right now. I don't want to discuss any particular litigation strategy here. That's up to the parties. And I want to have them sort of tip their hat here. But sort of review some of the more glaring issues of what the opinion said, and then I think the second thing, which is what are the broader implications, and in particular the precedential impact of this case for both communications law and administrative law. It really is a groundbreaking case. And then at the end, I'd like to sort of bring in the economics of that and talk about these rules are the law of the land and what we can sort of expect from that. So let's start the discussion, try to do it sequentially with the actual reclassification decision. When you look at the case, that was the central issue on appeal. The actual rules were not on appeal, but the reclassification was, and that's the big deal. So as the court, the argument was going back and forth, the central issue was whether or not the FCC could reclassify broadband internet access service or bias. The FCC argued the statute was ambiguous, and under Brand X and given Chevron deference, it should be accorded great deference to adapt, and the court basically bought that argument. Obviously, the appellants argued that the statute was unambiguous. There were definitional issues in terms of the way the internet ran, and the court obviously agreed with the FCC. And in fact, they even went along with the Commission's redefining of the PSTN in context of wireless reclassification. So on the definitional issue, I want to throw this out to Russ first. Do we think there are grounds for appeal here just on the definitional argument, the way the court looked at that in terms of the deference and the way that they looked at that?
Thanks for having me, and I was a little taken aback by your intro when you said that we were supposed to have read the decision. I didn't think that was required here, so just kidding.
And of all the people on this call, Russ, you get the bill for it, so there really is no excuse.
Right. So, and let me just second what you said, that although I represented various clients in the rulemaking and represented CenturyLink on appeal, I've actually not discussed litigation strategy with any of them yet. I think we've all been scrambling to read and, deal with other issues as the current commission tries to resolve every issue that's pending in the next several months. Are there grounds for appeal? Sure. That's not to speak of the likelihood of success on appeal, but yes, there are grounds for appeal. The petitioners, especially the group of petitioners that I was part of, which is the kind of USTelecom group, raised very serious challenge to the definitional on the definitional question, raised what I think were serious concerns about Congress's intentions in codifying terms in the 96 Act and the extent to which in codifying those terms, Congress was incorporating the FCC's then current understandings of how the world looked. The D.C. Circuit panel obviously had a view about the extent to which that was meant to be written in stone versus meant to be kind of a living, breathing definition. That was the court's view, but that's not to say that it's unassailable. And this may be something that either an en banc panel, or I think maybe more likely the Supreme Court does, or is asked to look at. And I think that would be sure there are grounds for appeal there.
Okay, Hank, what do you think?
So I'll start by saying, I think you said this up front, but these are highly preliminary sort of reactions to the opinion at this point. And just to be clear, these are purely my reactions to the opinion and in no way represent any more general AT&T view. And I guess I would say on the question, I'm sure Russ is right. I think that there are inevitably issues with such a complex decision, and I think that there are probably good grounds for challenging some of the decisions with respect to the reclassification. And I mean, I think as you brought out, Larry, there's a number of them related to the reclassification itself, to the application to wireless, to a number of factual distinctions that were made by the FCC and accepted by the court. So, yeah, I think Russ is right.
Okay. Well, again, I realize it's preliminary. So let's move on to that question, and I'm going to throw this to start with Jeff. And this is viewing the case again from a macro 30,000-foot level, from an ad law perspective and a communication law perspective, because I think the precedential value of this case is really important because this is now the law of the land. The big argument really between the majority and the dissent was that the majority said to reclassify, we don't need to do a cost-benefit analysis. This is strictly a statutory definitional issue, which the FCC can do. We don't need to look at the cost-benefit analysis. We don't have to do a market power analysis. We don't have to do that. What precedential value does this have in terms of administrative law? I think this is a really big deal because if the EPA typically has to do a cost-benefit analysis, or the CFPB, but yet the FCC now can essentially write a rule, whatever that rule may be, and go, well, it's because I said so. That's it. Is that what this case stands for?
I thank you for having me. I'm not sure I go quite that far, but I understand why you would react that way. I'm
supposed to be provocative. That's why I'm the moderator.
Exactly. Well, you're moderating well then, in an immoderate way.
Moderate way, good.
To me, the key distinction between the majority opinion and the dissent, it gets really kind of to as you said, a very fundamental question. The majority basically says that treats this like a case of first impression. And in fact, basically says that the FCC can go back to the beginning anytime it wants with respect to statutory interpretation in this circumstance. And what Judge Williams in dissent was saying fundamentally is, no, that's not right. That if you're changing your mind, if you're reclassifying as opposed to just classifying, it's a different burden, a higher standard, because we've had market reliance, we've had, society has operated under one approach, and so if you want to change the approach, that imposes a bunch of additional costs. So there is significant precedential impact in that basically the majority rejects the notion of reliance costs. And maybe not in so many words, but I think everybody who's argued this has understood that, or conceded to some degree in the first instance. It's two different questions. Could the FCC have classified the Internet as a telecom service in the first instance? And even the Brand X decision sort of said, well, yes, they could do that, or they could do the opposite and classify it as information service. They chose information service for what we think are very good policy reasons, and actually it worked out pretty well in the world. And there are very few complaints about how the world is operated. We now have the decision going the opposite way, classifying it as a utility, which will change things and produce significant policy changes over time, or could. In fact, the FCC is trying to avoid that, as Judge Wood has pointed out, by forbearing from all the rules they just adopted. But that is a significant question, whether the agency has the same latitude in the first instance and later when it changes its mind. I don't know that this is a carte blanche rejection of cost-benefit analysis, however. I didn't see that, but I did see a sort of cavalier disregard for the costs of changing.
Russ, what do you think about that?
It's hard to say. I mean, I do see in the decision, just a very expansive kind of deference. Whether it's more expansive than the overall body of precedent, whether it's an outlier, I have to say I haven't fully figured out. I think there are arguments that it's within the realm of deference ordinarily accorded to courts, but I also got a little bit of a sense of kind of this is a big, complicated policy matter, and there are lots of decisions here that are just within the ken of the expert agency, and therefore we're going to let them get there. Coincidentally, the day the decision was released, Judge Pillard from the D.C. Circuit spoke to the Federal Communications Bar Association. I know a few of you were there, and I suspect a few of the people listening in were there, or maybe more than a few. And she, I don't think this was aimed at this point, but she kind of underscored just that, her view anyway of the role of the court was when evaluating agency cases was really just to sort of make a very high-level view about whether the decision was outside the scope of what the agency was legally permitted to do, and that she doesn't have to like the decision. And I think there's a bit of that in this decision, that they're not looking to whether they like it or whether they think the FCC made the right decision, but just whether they made a decision within the bounds of authority. So, whether this is sort of a groundbreaking case in terms of agency deference, I think time will tell, because I think that's going to be at the core of whatever cert petitions or petitions for rehearing are filed. And if either court takes up the case, that's going to be obviously a core bone of contention there. And I guess we'll see.
Hey, Larry,
yeah, go ahead.
Jump in on this,
please.
And I think I very much agree with what Russ said. And I want to be clear, I'm not endorsing one view or the other, or saying I think one's right and the other's wrong. But I do think the dissent and the panel majority, have a very different approach to this question about, how extensive is the review of whether the agency has engaged in reasoned decision-making. And the majority takes a more formal view. Did the agency give reasons? The dissent says, wait a minute, I want to, peel back your reasons a little and see if they actually are good reasons. And that's a difference. I think that courts themselves, and possibly even the same judges, depending on the case, have a little variance in which of these they tend toward, whether or not in a given case they make a more formal review like the panel majority did and said, okay, did you give us reasons, versus, okay, the reasons you gave us don't make any sense. And so I do wonder whether it really has any significant precedent or not, because I do think judges themselves vary the extent to which they apply a more substantive review of the reasons given.
Yeah, and let's drill down a little bit on that, because I think what we're talking about here, and this is an important case in terms of, I think it goes to the nature of the regulatory state. As George and I were talking on the phone the other day after the case came out, George had a great line, and which is, who's watching the regulators? I mean, the idea is that the court is supposed to be that backstop. And you can go all the way back. I mean, one of my favorite ad law cases, the old Cincinnati Bell case, which dealt with when the FCC in its 1990s tried to do set-asides in the first PCS auction. And the court, I think it was the Sixth Circuit, said, it's a great ad law case, said, you provided no economic analysis, then we're striking this down. But here you have, and if you look at the Phoenix Center's writings, we have exposed numerous times where the FCC's logic was just totally flawed. And you read the case, and it almost looks like the D.C. Circuit just ran from the complexity. I mean, they didn't even go anywhere near it. But I think it does beg an interesting question. Again, who watches the regulators? Because if I understand that it's black letter admin law that court they don't want to get involved in the political aspect of it, and they're just there to see whether or not you provide a reasonable explanation. But yet, where is that check and balance here? Where is that having to do that? And I think that's an interesting problem. Russ, what do you think?
So I do think that is kind of a fruitful area of consideration, especially as folks debate whether and where to bring the case to appeal. So one line of discussion in some of the briefs, and in particular in some of the amicus briefs and the interveners briefs, was discussion of what might be a nascent doctrine forming at the Supreme Court about court review of agency decisions in a kind of what you might call especially important cases of national import, or in cases where the agency has appeared anyway, or arguably really kind of recrafted and reshaped what Congress gave it to do. And the key cases that folks cited below in the record are King versus Burwell, which was the, I think, Supreme Court's second Obamacare case, in which the court said at a very high level, in matters of great import to the nation, there may be more limited Chevron deference. And then a case called the Utility Air Regulators, or UARG, in which the court overturned, I think it was an EPA decision where the agency had taken the regime created by Congress and taken a lot of liberties with it to create what it thought was kind of a more appropriate policy regime, and the court effectively slapped back the agency saying, you don't get to do this, you don't get to reform the regime. And frankly, these are arguments that I always thought would play better at the Supreme Court, where this doctrine was still kind of taking shape, than at the D.C. Circuit. And I think we're going to be hearing a lot about cases like these, and I think they go to George's question about who watches the watchers here, and exactly how much discretion do agencies have. And I thought that, while I thought the decision obviously was very careful and very long and involved and took seriously the issues, whether or not it got them right, I did think it gave somewhat short shrift to these arguments, especially the utility air case. And the commission's response, the court's response to utility air was effectively that case is totally different than this case, because here Congress gave the agency forbearance authority, so the fact that it reclassified and then extensively forbore doesn't show that anything was amiss. It just showed that the commission was doing the thing that the agency was allowed to do. That might stand up on review, but it struck me that was a somewhat I don't want to say cavalier, but it was. I don't think it gave enough consideration to that point. So when Congress gave the FCC forbearance authority in Section 10, I think folks largely believe that was intended to be a deregulatory provision. It speaks about removing regulation and even removing the applicability or eliminating the applicability of statutory provisions. And to my eye, anyway, it does seem to be something strange about using it as a mechanism to vastly expand regulation, just not as far as it otherwise would have been expanded. So in other words, to shift the rules so that a lot more regulation applies and then use forbearance to claw back some of it, it strikes me as somewhat fundamentally different from just removing regulation. And I would not be at all surprised if petitions for certiorari, especially before the Supreme Court, talked about that issue and put squarely at issue this question George raises about how much authority do agencies have to just create regimes, I wouldn't say from whole cloth, but to create regimes that are quite different from the one set forth in the statute.
Yeah, I think that thank you, Russ. I think that's right on. I mean, Jeff, do you have thoughts on this?
I think that's a good segue into what in many ways is a core problem in this case, because it is one of national importance, but it's also one where it's very hard to figure out how to apply a statute that was written, 80 years ago, and in a very different world, how that should apply to the things that we're dealing with now. There really isn't a lot of precedent for that, and that I think there's two different views there as to whether we should allow the agency to go forth and do what it thinks is best in that situation, or whether that is something that's best left to Congress. Obviously, I think we feel the latter is true, but in that regard, at least, I thought the discussion, as Russ said, was thoughtful. So, I mean, it'll be interesting to see if a Supreme Court decides to take it, and if they do, how they would wrestle with it. 'Cause we don't even know what that Supreme Court would look like necessarily.
All right. Well, let me ask one more legal question about the case, and then we'll move on to the next topic. But I think this merits importance. I mean, one of the big issues that was raised throughout the appeal in multiple contexts was the concept of notice. And notice procedural arguments are sort of your fallback, but it was raised constantly throughout in terms, and again, the court made very short shrift to this. And we did, I guess, a webinar on, right before the appeal, and Russ was one of our participants. We thank Russ for doing that, and we were talking about the notice arguments. I remember Russ saying, at some point you still need to know the purpose of the notice in the APA is to ensure the due process, so you know what you're commenting on. And the standard of notice, just to sort of refresh everybody's recollection, is that you don't have to have, the end rule doesn't have to look exactly like what was proposed, but it's got to be reasonable outgrowth. And yet you had all of these issues. In fact, Hank and I were talking offline, and the court had actually said, well, Brand X, a case 11 years ago, supposedly gave you notice. So as an administrative law aspect of it is, I mean, how much, and particularly the way the FCC works, where, you have an NPRM, 1 year later we have a set of rules that never do anything. Is this another big issue in terms of procedural due process?
So I don't know if anyone else is speaking on mute, but given the silence, I will jump in again. First of all, that Russ guy seems like he was really smart, whatever he said a year ago. So on due process, on the notice issue, I guess I'd say a couple of things. One is I think what the court said here, especially with respect to the wireless issue on notice, is a little troubling. So the court, as I read it, says effectively, yes, true, the FCC didn't give great notice about what it had planned to do, but that's okay because the error was harmless because wireless wound up making all the arguments anyway. They wound up making the arguments on the issues, showing that they had actual notice and they weren't harmed by the absence of notice in the NPRM. So two concerns about that. One is there's precedent that says that what parties say in comments cannot cure defective notice. In other words, the agency has to ask about it. It's not enough that a party brings it up on its own. And second, as a counsel, as outside counsel especially, I worry about the strategic choices that places on litigants and on their counsels. So I happened to represent wireless parties below here, so I guess thanks to the court for recognizing we made good arguments. But what it means is that going forward, when the agency has not necessarily noticed an issue properly, parties have to give a lot of thought to whether to address those issues. If they foresee them as possibly becoming relevant, they have to decide, do I make the argument so I know that the agency knows my views and has the appropriate legal sources in front of it, or do I intentionally ignore it so that I later have a good notice claim that I haven't destroyed by actually engaging in advocacy on the issue? And I just don't think that those are strategic choices we want parties making. Put more bluntly, I don't think we want parties to have incentives not to make the good arguments and not to put the relevant authorities in front of the court. And I worry that this kind of decision may promote that.
So I'd like to jump in on that, Larry. I mean, I think the problem, as Russ's comments bring out from sort of an admin law perspective, is there are precedents here going either way. And so the court might say in one case, a panel might say, you know what, you weren't harmed by this lack of notice because you had the chance to make the arguments anyway, and so therefore we're going to, not vacate this decision. Then another court might say, there is a requirement that this be included in the notice, and it wasn't there, so they're going to vacate. And that kind of not knowing whether or not a court might apply a stricter or a less strict approach to this notice question, I think is very harmful, both from as Russ brings out, from a how do you know what to do below perspective, and ultimately, what advice can you give your clients? It would be, I think, much better to have a clearer, bright line in this area if it were possible. And then just to, sort of bring out, the comment you made earlier, going, away from the wireless side and to the general reclassification, I did find it somewhat remarkable that on the question, and this is a very down deep in the details question, on the question of whether or not parties had noticed that the FCC might determine that domain name service fell within the telecommunications management exception, and the court relied on that, on something that was said in the dissent to the Brand X case, effectively saying that parties had noticed that the commission might do that because it was mentioned by the dissent in the Brand X case. And that really did jump out at me as a very expansive, view of the realm to which parties are expected to look in order to determine whether something may be part of a proceeding.
Well, as I like to say, Hank, ignorance of the law is no excuse. No, I think you're right. I think that's really important. Okay, well, let's shift gears here slightly. And it was an excellent discussion, but I think the next really big topic that we need to talk about is, for better or for worse, USTelecom is now the law of the land. There may be an appeal. We don't know how long the appeal is, but we now have, let's assume that, the regime is here to stay. So again, based on this, because the court focused on reclassification, the court left the agencies, what I would describe as the agency's tortured interpretation of Title II, whether it's tariffing, forbearance, the just and reasonable standard, untouched. But now the next task is the FCC now has to implement these rules. And that is going to be a really difficult task. So a couple questions here for everybody. We're all practicing attorneys, except for George. First off, what's the prospect of these rules being litigated, the actual implementation of these rules in the future as a result of how the FCC's actions? I mean, what do you think the prospects are of Kerry baiting the FCC to fight over, I don't know, zero price termination or something like that? Free, all that kind of stuff. So, or just even if you just want to take, what do you see as the first really big legal pothole the FCC is going to face in implementation? Hank, I'll throw that one to you first, please.
Oh, thanks. Not sure if I'm ready for that. Obviously the FCC has certain things underway already that will continue related to, for example, the CP&I proceeding. Mm-hmm. And so, how it deals with those issues, I think, is complicated and could give rise to further challenges to both the particular decisions it makes and the basis for the decisions. And I think the more, other than those proceedings that are already underway, the other area in which at least I would expect there to be, I don't know if I would call it potholes, I would say decisions the FCC will have to make would be to the extent that third parties seek to force the FCC, in effect, to decide issues through the filing of complaints or other approaches that, let's say, somebody doesn't like usage-based pricing. And mm-hmm. so they ask the FCC to determine that this pricing scheme is not just and reasonable. The FCC will have to figure out how it handles that. Obviously, there's been a lot of back and forth about whether the FCC is or is not going to engage in rate regulation. And I think that kind of proceeding would bring that issue forward, and whether you can call it a pothole or not.
I think that's right, Hank. And what you call the TP&I proceeding, and other people speak of as the privacy proceeding, which is obviously underway, is a very big deal. It's a very clear illustration of whether you want to call it potholes or just the new reality. in the utility world, the notion was very strongly kind of in favor. It was written. Title II was written for what was thought to be a natural monopoly, and the goal was to try to, contain it. There were obviously major investment issues as a result, and so then we had decades of trying to figure out how to get investment in this utility we really wanted, while sort of limiting the ability to run the business. And now, if we bring that sort of change in privacy focus, there's a lot of debate and discussion about how will we, if we take that restrictive approach to the broadband providers, what about all the other participants in the internet ecosystem who are operating on a very different model? I noted that Mary Meeker recently called the proceeding really about whether to use Title II to protect Google's online advertising monopoly. And that's not an unreasonable way from a business perspective to characterize the proceeding. So that's the kind of thing we're going to start to see. They'll come along, and as Hank said, they don't have to come along, necessarily, but the process will bring them up, and by having third parties be able to bring complaints, we're going to see a lot of discussion around sort of how the world's going to change, because it will change. It's not how we operated the past 15 years. And I think, as the dissent, Judge Williams pointed out, the irony of applying natural monopoly regulation to a market is you might actually produce the natural monopoly that you were assuming in the first instance. In other words, it's not a friendly regime for competition.
Thank you, Jeff. Russ, what are your thoughts on this?
So I think the FCC is faced now with what I'm going to call the SpiderMan issue. So comic book folks, and maybe in this age of comic book movies, people who aren't comic book folks know that sort of the motto associated with SpiderMan is with great power comes great responsibility. Mm-hmm. So the FCC has, whether one likes it or not, been now afforded a great deal of discretion in interpreting and implementing these rules. Particularly, of course, I'm thinking of the general conduct standard. But more broadly than that, the court effectively says, yes, there's some ambiguity. That's how common law process works. The FCC's got to apply it case by case. Parties can figure out what they're allowed to do and what they're not allowed to do. And if not, they can seek advisory opinions from the FCC. As an aside, I think any practitioner in this area knows that that's probably not quite as feasible an option as the court may have thought. But there you are. So great power, great responsibility comes down to the commission has said in the order it plans to apply these rules, especially the general conduct standard, in a way that preserves innovation and preserves competition and enhances consumer value, which means that it won't apply them rigidly or dogmatically. And as I think Jeff mentioned a few minutes ago, it has at least said it will not regulate rates. But there's some cause for concern. And just to take two public examples, with apologies to Hank, one of them is the AT&T NAL, which dealt with the previous set of rules, not these set of rules, but gives a sense of how the FCC thinks about some of these issues. I'm sorry, it deals with the transparency rule, which still exists, but just was adopted in the 2010 order. So the AT&T NAL, and then the very recent guidance issued by a few of the bureaus on transparency. Those are both really prescriptive documents. The AT&T NAL effectively tells parties how it thinks they need to describe what they do, and in a pretty high level of detail, how they need to characterize their programs, how it can use certain words like unlimited. And the transparency guidance issued a few weeks ago similarly gets quite in the weeds in the guise of effective safe harbors and sort of guidance as to how one might comply, but in a way that parties are going to view as being fairly definitive about what they need to do in order to stay clear of FCC enforcement. Probably everyone on this call knows that the Enforcement Bureau has been extremely aggressive in the last few years, and as someone who advises companies, the upshot of that is that parties tend to be very conservative. So, I mean, as outside counsel, it's my job, in a sense, to be conservative in counseling clients as to what they can do. So when you look at documents like the guidance and like the AT&T NAL, one has to go. I mean, I find myself saying almost every day, certainly every week, to clients, I just can't tell you that is safe. We can, you can try it, but you're at risk. If you want to eliminate all risk, here's what you'd have to do, and you wind up in an extremely conservative position that, frankly, is inimical to ongoing innovation and, in many cases, inimical to promoting and expanding customer value. So, with great power comes great responsibility, and what the FCC needs to do here is not sort of beat its chest and exercise its newfound or newly confirmed powers very aggressively, but needs to, I think, send signals to industry and to the ecosystem as a whole that while it is serious about its open internet regime and will take actions to protect it, it is not going to apply it in a kind of mechanistic way that hurts competition, hurts consumers, hurts innovation.
Thanks, Russ. That was very interesting. Well, just building on what you just said just a moment ago, and I throw this out to the thing. I mean, again, you've the presidential value. I mean, the USTelecom turned on reclassification. Yet you have this, as I said a moment ago, this tortured interpretation of Title II. Do we see? And so you just, in my mind, you just have this. I think as Russ just illustrated, you have this legal mess of how then do you comply. We have Title II, but we don't really have Title II, and it's still out there. Do we think that the FCC, again, with great powers, great responsibility, is going to use this to, dare I say, embolden itself on what it wants to do? After Verizon, the decision came out, you got Section 706, that was just, everything was Section 706. We had Municipal Broadband under 7, just anything you think of through under 706. Do you think this case gives the FCC additional, or the FCC would perceive they have additional strength to do what they want and pursue an even more aggressive agenda? Hank, what do you think?
Well, it won't give them less. So, I will not put myself in the mind of the decision makers at the FCC. They are, very smart people, and I'm sure they think they see many of the same issues that we have been talking about. Ultimately, how do they then act? I hesitate to predict. I certainly hope that they sort of take Russ's counsel and, approach this with not a dogmatic mindset and really approach it from the perspective of, continuing to, at least enabling innovation and letting people experiment with business models and all of that. That's hope. I guess I'll not take an opinion on what they will do.
Okay. Jeff, what do you think?
Well, I think what Hank says is exactly right. This isn't going to reduce the FCC's incentives. I think it's a good reminder, this whole proceeding, including how we got to Title II, is a good reminder that the FCC is fundamentally, in practice at least, if not by design, I would argue probably by design as well, a political body. It is part of our little d democracy. And so I think the question you asked is very much going to be decided by how our politics play out going forward, and the direct and indirect impacts that has back on the FCC. The FCC has a second job, which is to administer and enforce. It's supposed to be less political there. We'll see if it manages to keep its roles separate, its rulemaking separate from its administration. But in some ways, by being more political, the administration job and making sure things sort of work out and trying to guard against bad outcomes has probably become harder. And it will be interesting for all and require a lot of work to make sure that, to try to prevent bad outcomes.
Well, okay, great. Russ, you have one more to add on this? Or?
I would just note, Larry, you mentioned in passing the Municipal Broadband case, which is still pending, and I think which we discussed in a previous telebriefing. So, and Jeff, I think was there for that too. I would just say, it's entirely possible that, within the next week that court comes down and says that the FCC overreached, and then we'll be in a place where they've, won one and lost one on these kind of issues, and maybe we'll be a little more modest as a result. But sure, I mean, when you win, you've won, and when you win in a decision that affords you that so much deference, I suspect the discussions, especially at the Office of General Counsel, are not right now focused on, oh my God, how do we make sure we're more careful the next time, but sort of are recognizing that they've been given a pretty long leash here.
All right, well, shifting gears one last time for our final topic, I would be remiss if we did not have some thoughts by our chief economist, Dr. Ford. We did say we were going to do both a legal postmortem and an economic postmortem. I wanted to give George a couple of minutes at the end here. As I said a moment ago, this is the law of the land. And as we talked about for the last hour, the court has said, I'm not getting involved in the policy decisions, but I think it's important to, now that we know what these rules are, to talk about what this may mean. The Phoenix Center's done a tremendous amount of work on net neutrality over the last 10 years, most of which we have been predicting has actually unfortunately come true. And so I want to turn it over to George here for a couple minutes to sort of talk about, regardless of what the law may be, now we do have the policy because this is the law of land, and then what do we do for next steps? So, George, if you wouldn't mind just a few moments, please.
Sure, and it kind of flows what we've been talking about here in the last few minutes. I remember back in 2008, I guess, when we had our symposium, I had predicted that that we would end up with more regulation of the industry, not less regulation of the industry, given the change in the cost of implementing regulation by the change in regime, and I think that's pretty much come to fruition. I think we'll see, at least in the short run, an expansion in efforts to regulate the industry, and generally even more deaf ears from the oppositions to whatever political agenda is in force at the FCC at the moment. We had, I think, going forward, that we kind of continue down the road we've been on. We talked years ago about how the commoditization of the internet service, which I think you detect that in the decision, where broadband becomes a transmission service alone. There's not a lot of room for margin in that kind of environment, and as the margins shrink, the ability to fund these very expensive networks, the investment in these networks declines, and so we should expect to see continued pressure for increased consolidation, and now, given the new policies on care of last resort, that sort of thing, an exit, increasing exit from marginal communities, which puts more pressure on the Universal Service Fund. I think we'll also see the continued efforts, as we predicted years ago, of vertical integration of the networks into the content or edge business. Almost all the mergers in the business now are vertical in nature. That's going to continue if the core cannot share in the growth of the Internet's edge, which a competitive market would ensure. FCC rules here are prohibiting what a competitive market would actually produce. Then the option is to get in the content business, to try to gather it up that way. So we'll see, I think, continued vertical integration. Going back a bit, I think, to what was talked about earlier, since my name was invoked, I think in my reading of the decision, there wasn't a lot interesting there for me. I prefer when the court vacates decisions, because then there's a problem to solve, and there's trying to figure out what the court was thinking and how to fix the problem. and here we don't have that. But I thought the dissent was interesting in a couple of respects. One was pointing to the fact that this will probably lead to increased consolidation in the industry and concentration in the industry and possibly monopoly, which some people would argue is the goal, in fact, of these decisions, to drive the industry to natural monopoly conditions and then turn it over to the government in a municipal broadband type model. The other thing was the dissent mentioned the sort of lack of economic integrity at the commission, and I think it's quite profound. It's always been there, of course, but when you have a judge say the FCC makes an argument and cites 4 papers, and I've read all 4 papers, and none of the 4 papers supports what it's saying, that happens all the time. In the first order, in fact, the FCC said cited a paper for the proposition on investment, network neutrality and investment, and then said there was no evidence to suggest that if we did have two-sided pricing, that if you charge the edge providers to terminate, that the price of the user would go down, when that very same paper had a formal proof of that proposition. In fact, the title of the section of the proof was that if you charge a high price on the termination side, you get lower prices on the user side. So I think that's a big deal, and I don't know from a legal perspective. It may be political that we need an organization that actually reviews regulatory decisions from the perspective of the validity of the economic analysis, if that would be helpful. I know they do that in Europe, at least in the UK, and it can be quite effective when a group of economists and lawyers say the agency is misleading here and is not reading this, presenting this topic with integrity. That we may need something like that. Something's got to happen, because the opinion basically says the FCC said that there was evidence to support this, and then you look at the evidence, and the evidence doesn't support it. And it's always been the case. It's not unique to this commission, although I think this commission uses it more than others. As an example, the virtuous circle is an argument against network neutrality, not for it. A virtuous circle is virtuous, it's self-enforcing. You don't need regulation. There's an unvirtuous element of this circle that has not been specifically described by the agency to justify its intervention. But the idea of a virtuous circle makes economic sense, but it makes economic sense in a deregulated environment. So I just don't know how you solve that problem or what we do going forward. This also reminds me a bit of the unbundling days, not in the sense that this is unbundling, but what we had there was we had the Supreme Court supporting the FCC's policies on unbundling, but we knew that these rules were being implemented and imposed and challenged on a regular basis, I mean, just consistently. And we knew, at least some of us knew, that eventually we were going to lose in these courts. And I think that's the same issue we have here, is that as the FCC begins to implement these rules, I mean, because the decision really only goes to the reclassification decision, not the rules. As the rules become implemented and then they become challenged as being incompatible with the Section 201 and 202, that we begin, the thing starts to fall apart from the bottom up. It's sort of I think the whole thing is kind of built on a house of cards a bit. And as we start pulling out pieces, in fact, any individual piece that could be challenged, a zero price, for example, if that were challenged, then the whole thing falls apart, because the no blocking rule, for example, is a zero price regulation. And certainly the pay prioritization rule is, if challenged alone, standing by itself, rather than within this larger context of reclassification, I think it would suffer significantly when the lens gets focused on those very narrow issues. So I think for me, we're going to see what the economics would predict, and we're going to see eventually, as the court gropes to the efficient solution, which is what we in law and economics believe happens over time, that the inefficiencies that are embedded in this thinking will begin to be exposed as courts review narrow issues rather than these very, very broad, sort of large politically driven issues. And as Larry and I always thought that the real threat here was more in the rules than in the reclassification. So it would be interesting to see how that plays out, and interesting to see how regulation really develops over time. I mean, we just did a big paper on sort of the rule of law and the end of precedent in regulation as we start bundling issues together, for example, mergers. And I don't know if we're just on a track for some really bad decisions, or sort of regulators unhinged from the law through both bundling and through extreme deference, and whether or not we need law, which I don't think really is possible at this point, to try to curb that activity and bring us, out of the third world of regulation where we are now. If you look at it from the economic literature, we're arguing about things that people argue about when you're trying to develop regulatory regimes in third world countries. The separation, for example, of political influence from the regulatory agency. In third world countries, the regulator is the political body, and the separation of those two is very important for continued investment and so forth. So these are interesting times, and I think that we will see this thing rise up for a bit, but I think there's a decision out there that could just make the whole thing crumble.
Well, thank you, George. Well, we've now come to the top of the hour, and I appreciate everybody who's been on this call, our audience who's listened in. I want to certainly thank our excellent panelists, Jeff Lanning, Hank Hultquist, and Russ Hanser. I appreciate your time for participating. I hope the audience enjoyed this. And in the shameless plug, if you thought this was nice, we're going to do it twice. I hope anybody who's in Washington will be coming to the Phoenix Center's annual Rooftop Policy Roundtable next Wednesday, which is the 22nd. That's when we go up on the roof of the University Club, have an open bar, go through about 4 boxes of cigars, and talk policy much this way. It's a wonderful event. This year's topic will be all of it. You can find the registration information right there on our webpage, www.phoenix-center.org. Again, I'd like to thank our audience for tuning in, our panelists. I hope you enjoyed it, and we will catch you at the next event. Thank you very much, everybody. Appreciate it.